and feel free to follow along. So we're going to go to Homer Simpson and as an example for our appointments. Now, we can appoint different people in different roles. So we have estate trustee appointments, we have appointments for powers of attorney, for property, personal care, we have guardians, we have different trustees if we want what we call gift trustees. If we set up a trust in the will and we want somebody other than the executors to be appointed, we can set up different people for that role. And the appointments all work the same way. And I'm going to start with the estate trustees appointments. So to add an estate trustee, you find the appointment tab right here, and you'll have two options. You'll have the guardians and the estate trustees, which are both appointed in the same tab. Pretty straightforward. We want to add our first appointee. Up comes the list of everybody who is in our family tree or has been added as a person comes up. And we can very easily just pick whoever we want. In this case, the most typical one, let's just pick the spouse as the first estate trustee, what we call the primary estate trustee. Whenever you pick a person, there's a spot here for conditions. Conditions are a condition on their appointment. You act if, for example. In this case, there's no real if. Marge is a primary appointee. She's the first appointee, so she's going to act without condition. And so we're going to add that. And you can see Marjorie is identified as a primary with no conditions. That's easy if we want to add one person. Let's now add, it's a rare case where you'd only add one person. You'd want to have another person either as an alternate or a co-trustee. Let me show you how to add a co-trustee. So we would again, we've got Marge there, but we'd again add another person. And let's say we want Abraham as a co-trustee. We would click on Abraham, click done. And now again, if Abraham is going to act with Marge, there's no condition on his appointment. So I'm going to just click add. And now you can see that we have two estate trustees, both primary. That means Marge and Abraham are appointed jointly. Okay. In a will, and I don't know if Ian's here or not, but he could speak to this. In a will, there's no such thing really as a joint and several appointment. We do use that in powers of attorney. In our law, there's really no such thing for estate trustees. Estate trustees are both appointed. One can't make a decision without the other unless the will subscribes some sort of limit to their authority. So you should not think about using joint and several appointments in a will for estate trustees. So in fact, you'll see that eState doesn't even give that option, okay, for decision making. It will once we get to more than two. So we've got Marge here and we've got Abraham, and I'm going to talk about these additional provisions in 1 second. I'm going to add a third. And again, if it's going to be a third primary, let's add Daniel. Again, no condition because we want Daniel to act irregardless of anything else. So there we go. We now have 3 primaries. Well, now we have some decision-making options to think about. So you can see additional provisions here, and we click on decision-making, and eState knows how many people are appointed. So at one time, so it's going to give us certain options. It knows that we could have more than 2 people acting at any one time. So it gives us the option for majority rule, unanimous, or some other. Now, I've never used other, but if you can come up with it, go for it. So let's talk about majority rule. If the client says, yes, I want to appoint these 3 people and I want a majority rule, that's fine. We give 2 more options. So we could have a simple majority. That means any 2, in this case, any 2, because it's 2 out of 3, any majority, any people can form the majority. Or in some cases, you say, look, I want a majority rule, but I want Marge, my spouse, to be part of that majority, or else it's not a majority. So in other words, As long as Marge and one other person agrees, that's fine. But the two other people cannot overrule her. And so that's what is meant here in decision-making by specified appointees must be part of majority. And that's distinct from simple majority. And again, that's going to depend on your discussions with the client. You see that sometimes in a spousal trust situation where the executors are also the trustees, and you want them, you want the spouse to have a veto in essence. And that's when you would use specified appointee to be part of the majority. Most commonly, I would say, is simple majority when you have more than two people. We can also add a dispute resolution clause that you can say, look, if there's if you were appointing two people, you might use this and say, look, if there's a dispute as between the two, I want you to go to mediation or consult with someone else. And who do you want them to consult with? And so this is more of a, you're going to need to draft this a little bit to make sure it works accurately with what your client's specific intentions are. But at least it's in the data model to remind you, and it'll print out something as well in there. You can, so these are kind of the most common, and without sort of talking about eState specifically, if there's a dispute, you might say, look, go to mediation or consult with this third party or go to arbitration. Or if you're fighting, guess what? You all resign. And I've used that in cases where I have a backup, and you should definitely consider having a backup executor, because and often we use a trust company, and that's sort of the carrot and the stick. If you're fighting so much, great, we'll get somebody who's going to charge you a lot of money and to take over, and then you'll get less money if you're fighting. So that's the dispute resolution. And then we have compensation. Our default is the court discretion, which is our typical leave it up to the court or the consent of the beneficiaries, or if the beneficiaries can't agree or won't agree, then the court will determine the amount of compensation. That is our law by default in Ontario, and so that's our default. We also have options for fixing the compensation by an agreement. So you see that a lot in situations with trust companies, where you're doing that. The other option is where you want to fix the amount, a specific amount in the document, and you can do that on an hourly basis, a lump sum, a percentage. You can just simply pick that from here and say, look, I want my executors to each get paid $250 an hour, and allow pre-taking, and I could go done, and that's what will happen. So far, so good. I'm going to explain about alternates now, and how those work. Anybody have any questions to this point? And we'll talk about sort of how do we build in replacements for or alternate estate trustees. If you have a question, just unmute and fire away.
Hi, Jordy. It's
Hi,
Tim here.
Hey.
I got a question with regards to an executor that lives out of the country, and whether that's something that should be somehow addressed in the plan.
Right.
Because the concern was that maybe the estate asset would be administered in that country and then be subject to tax or something.
Yeah. So foreign non-resident beneficiary or non-resident executors can cause issues in some cases, because it could render the estate as a non-resident estate. So the general preference is not to appoint non-residents of Canada to be estate trustees, or at least have alternates appointed. So, for example, in our situation, so let me get rid of this for a second. So I'm going to give an example for that. And let's say we have Marge first, and then we want to appoint, Mary. And Mary is a non-resident, let's say. So let's go through this one by one. So we're going to appoint Mary, but the condition for Mary, it's not unconditional. There's a condition for Mary, and that's if Marge cannot act. So we go condition, add, if specified, cannot act. And then we pick the person who they're going to replace. So if Marge can't act, that's when I want Mary to act, right? So that's our condition. And we add that. And eState will always reorder things so that it lists the primaries and then the alternates and then the further alternates, because we can add further alternates. We can say, if Mary can't act, then I want Lisa. And so we want Lisa to act if, add a condition, if not if Marge can't act, but if Mary cannot act. Okay. But we have two people replacing Mary. Okay. And then Tim, I'll get you the answer in a second. We also want, if Mary can't act, we want Lisa and John to act. So we already added Lisa, but we're going to also add John, and John can't act, can only act if Mary cannot act. So now what we have is Marge first, Mary if Marge can't act, and then if Mary can't act, John and Lisa. That's how we can do it. Now we can even replace, and I promised him I'll get to your answer. We can also, rather than replacing, when we have two people, here we have John and Lisa, we can replace both or either. So let me give you an example. We want Marge, then Mary, then John and Lisa. But if both John and Lisa can't act, we want someone else. So how do we do that? Well, then we add the other person. So we want Abraham to act if both John and Lisa can't act. So the condition is if both cannot act. So it's if Lisa can't act and if John can't act. Okay. Once you add more than one person that you're replacing, eState's going to ask you a question. Do you only want them to act if both cannot act, or if either of them or any of them can't act? In this case, we want to only have Abraham act if both Lisa and John can act. So then we have if all cannot act. And there we go. If, on the other hand, as an example, I wanted Abraham to act only if, in case of either of them not being able to act. So Lisa dies, but John's still available. Well, I want Abraham to step into Lisa's shoes. Then we're going to pick Lisa and John, and then if any cannot act. And of course, it's going to draft it differently, depending on what you pick. So does that make sense as far as how you appoint replacements?
Yeah, it does. Yeah, so my foreign executor really could in my situation, he could have a replacement if it becomes a problem with.
Exactly.
Yeah.
Okay. That's exactly what I would recommend. Like often we have and I'm sure many people have this, where they have a kid who's a US person. Okay. And we know it's not great to have a US person or non-resident. And you're like, well, what should I not name them? And I'm like, well, listen, why don't you name them? But have an alternate. If that's the only person you want to name, like still have an alternate, because at the time, A, they may not be resident in the United States. B, it might not be a problem that they're a resident in the United States by then. Three, they may want the option to stay on and say, you know what, the problems I'm going to have as a US based estate trustee in the US, I'm okay with it. I'll deal with it. I want to stay on. So that's my typical discussion with the client. Yes, there are, there's the dispensing with the bond, and there's the US disclosure requirements and things like that, and the logistics of things. But maybe your kid wants that. Doesn't matter to them. They're okay with that. Well, that makes sense.
Yeah.
So I would just think for sure, Tim, that have an alternate in case it doesn't make sense.
Perfect. Thanks.
All right. So that's yeah. So there was a question basically, if you have two kids and one's Canadian, the other's not, is it a US estate? Is it not? Typically, it's more the trust that you're concerned about. You're mostly concerned about trust, not so much the estate being a US estate, because typically Canada looks at it as where was the testator domiciled when they died, right? Because that's kind of the instant of death. It's when you're setting up, when there are trusts in the will, now you look at who the trustees are, and it's a bigger problem. So I'm not typically too worried about the residency of the executor so much as the problem is they're also a trustee. That causes more problem. Now, I'm not a tax guy, so if you have questions about that, I would ask your tax advisor about the new any specific rules about that. My experience is that it's not a tax issue at the estate level immediately. So that's the way we appoint people. And of course, so it's again looking at eState can figure out how many potential estate trustees there are. Right now, you'll see majority rules not offered because if you do the math, there can never be more than 2 people acting. As soon as there is a possibility of more than 2 people acting, then we get into that situation where it offers the majority rule clause, et cetera. So that's how you appoint. That's how we do appointments in eState, and it's the same for guardians, same for attorneys, and for property and personal care. The same mechanism. You go to the condition if you're adding an alternate, and you put in that condition, and you go from there. So that's basically the formal part of the program. But I'm happy to take any questions about eState, about if you have questions first, maybe about appointments. Happy to take that those questions as well first, and then we're happy to take any other ones. Is that all? Yep. Lydia, do you have a question? Anyone? Nope. So hopefully that works for everybody. And again, the drafting will be different depending on what order you appoint people in and what alternates and all of that. So while we have a couple of minutes, I just want to show you a few things, a new feature that we have now. So if I'm creating a scenario for Homer, and Homer has, let's say, pets. Okay. Now we're going to drag pets in there. So I want, Abraham to be the pet recipient, and I deal with compensation for the pet recipient, whatever I'm going to do, whatever. Now, where we never had until Friday, we released a new feature. We now have a simple gift over for pets and personal effects. So if you want Abraham to be the first person to get the pet, and then if he can't do it, we can add an alternate. Then I want Bart. Why you would want Bart to be the alternate? That would be dangerous, I guess. But then we can have Bart. Or then we can, if Bart can't do it, then we want Glenda. So we can add as many, and I call these the simple gift overs, because we're not allowing you to divide it. Like, okay, so-and-so gets 40% of the pet. And so very simple. You can add more than one person, but it's always sort of together. And that's how we've done it to make it simple. So just to show you how to do that again, I'll just remove this and show you. So, and the same applies. I'll just do it, show you it's the same for personal effects. So if I've got a personal effect here, I want my personal effects to go to Daniel. And you can do this with jewelry or anything else. But if Daniel's not alive, then I want it to go, and I'll show you again, gift over, add. You'll click on alternate beneficiaries. And then you'll add the beneficiary that you want as the alternate. And it can be one or more people. So if I want those personal effects to go to Abraham and Bart, I'll click them both and go done. And now those personal effects will first go to, forget whoever I gave it to first, Daniel. And then if he's not alive, Abraham and Bart. Okay. And if they're not alive, I can say then Glenda. Okay. So that's a brand new feature that we've just added, because many people asked, why can't we provide gift overs for jewelry, for example? And one of the reasons was we didn't want people to trying to do percentages and all of those other things. So we just made a simple gift over for those kinds of assets that we don't need to get too fussed about as far as gift overs and making fancy gift overs. So that's that. So that's a new feature. We also, I'm trying to think of what other features. Well, Michaela, I got one. Let me show you one other feature. We released a bunch of features on Friday. Another one is your choice. So we used to, and you'll see this now if you've gone in, you used to have an option here for designation of RSPs if you wanted to include an RSP designation in your will. We've moved that because now we offer more options. So now you'll see here, and again, anytime you create a will or you go into your documents tab to customize a document, we've got the designation options. And I'm just going to click on that to open that up. And you will, to start with, have just registered plans as a default, including them. You can exclude them if you don't use RSP designations in your wills, and by default you don't want to include them, and then you can just click on the three dots and exclude, and now that won't automatically appear. Okay, so that's like checking the checkbox in the old days, like last week. But let me show you what additional features we have. So we add content here, and we now allow you, if you prefer, to include not only your registered designations for RSPs and TFSAs, but life insurance declarations in your will. So we always, my preference was a separate document, an insurance declaration. But many people like to just put it right in the body of the will. And so you can do that by just clicking that and including that. And same for our old joint and designated asset confirmation. So if I want all three of them to appear by default in my will, it will do that. And I'll just show you one more time where to find that. So, oops. So here's where to find that. You go to documents, right? If we were on the client page, here's all of our clients. We would go to documents and then pick whatever will you want to customize. Let's say the single will, and then you'll see designation options. Click on that and just figure out which ones you want to include and which ones you don't. So that's what we have there. Now, just so you know, if you don't make it, if you don't give the life insurance away, or the client doesn't have life insurance, there's not going to be a life insurance declaration, just as you would expect. And same for RSP designations. If you haven't gifted them in some way in our joint and designated asset section, then they won't appear in the will. So in case you're worried about that, and we'll do a special presentation maybe next week. Why don't we do next week, Michaela? We're going to do joint. We're going to do designated designations of life insurance and RSPs, and how to do those in eState and where to put them, and the impact of that on the will and things like that. So that will be next week's topic. Any questions or anything else that I can help with? Great. Well, thanks everybody. And as you know, I remind everybody that we've got the question mark. Whenever you're in eState and you don't know what to do, click on the question mark. It'll take you to our help desk where you can type in help for things. But it also, you can just click on the bottom right for the chat and be in touch with one of us at eState, whether it's me or Michaela or Greer or Lauren or Nick, and we can help you through it. Jump on a Zoom with you and show you how to do it. So we don't want you wasting time. I don't know how to create an alternate estate trustee. Don't waste your time. Jump on here. If you type it into help desk or jump on live chat, and we'll do our best to get right back to you. Thanks everybody for your great support of eState, and we'll see you again next week. Thanks.